did some in service.
Yeah, but when I meet president of the, you always have a lot. You have to put them in
Good morning and welcome all. And so we are gathered again for the fourth time this year to say farewell to another judge of the Court of Appeal. On this occasion, to Justice James Christopher Aboud on his retirement. We welcome all of you who have come out today, especially Justice Aboud's dear wife, Shan, and other members of his family. Some are also viewing online. This type of gathering is becoming a habit. Some might say bad habits, since we are losing some of our best and brightest who have contributed so much to the judiciary and to the profession of law. Justice Aboud is no exception to this description. His has been a long career, a career of service, one where he gave up lucrative commercial private practice to join the bench, first as an acting judge and then permanently. Like me, he joined the Court of Appeal in 2020. In one of our first appeal hearings, with us barely having a month's experience in the Court of Appeal, we boldly teamed up to form the majority in a particular case, with one of the most distinguished and prolific senior judges finding himself in the minority. I will leave Justice Aboud to tell the story of how that ended up, if he chooses to do so today. Justice Aboud can fairly be said to be a fearless judge. He called cases as he saw them intellectually and was never afraid to make a strong decision, decisions which might affect the mighty and powerful. The interest of justice was central to his judicial philosophy. He stood up for the law and was always conscious of how judgments we give impact on the vulnerable litigant. Justice Aboud, and everyone here today knows this, loves to talk. He has opinions, and he's not afraid to express them. He particularly liked to take a contrary view to his good friend on the Court of Appeal, Justice Nolan Barrow. But this affinity for talking has had a significant and positive impact on the court lists. Many a case has been settled to the satisfaction of the parties, either because Justice Aboud showed the parties the practicalities and justice of the case, or he talked them into exasperation and they gave up to get him to stop. Whatever the reason, the judiciary is eternally grateful to him for the healthy disposal rate he was able to achieve. He was someone who could show the parties home. His talent, and I'm putting him on notice, can be put to good measure as a settlement judge in his retirement when he's unfettered by having to write judgments. Another aspect of his loquaciousness is that he's a man who would express his views with brutal honesty, but he would temper them as needed. In doing so, he held malice to no one. Justice Aboud is immensely proud of his family, and especially of his girls. He talks about them all of the time, not in a boastful way, even though he has much to boast about them for, but as a reflection of the genuine love and caring he has for them. He is proud of his Arab ancestry, and he considered it an honor to be the first judge of his heritage in Trinidad and Tobago. He was, and remains, a very human judge. He brought the human touch to every case he dealt with. Of course, the thing we will all remember Justice Aboud for is his facility with the English language. Whenever a draft judgment was sent to him for review, it always ended up better after his careful analysis. He strengthened its content in substance, but also in the elegance of language that his changes would reflect. He was the ultimate grammar police. When, at the end of a hearing, I wished people a good rest of the day, he would remind me it should be remainder of the day. Even now, I am nervous in this contribution for any errors he might yet correct me about. He loves language. He's an accomplished and published poet, and this will form a key plank of his legacy. While Justice Aboud may have occasionally made each of us pull out a few strands of hair, well, those of us who still have, all of my colleagues will be at one to say that it was an exceptional pleasure and privilege to work with Justice Aboud. That is, when he finally skated into the building. His humor, his banter, his expressions, his baiting of those he cared the most for, Peter, his long stories, his all made for a more harmonious and fun working environment. He's a wonderful joke teller. Those of us who were there will never forget his Mr. Lashley joke, which he delivered after hours over drinks at one of our Tobago retreats. Justice Rahim and others had to be helped off the floor after Aboud's carefully delivered punchline. It is a pity that he can't tell that joke in this forum. Justice Aboud brought us together, and he brought a unique perspective to the work of the Court of Appeal and the judiciary. His well-written scholarly judgments will long be quoted. On a personal note, Justice Aboud has been enormously encouraging and supportive of me in these past few months, and I will forever recall his kind words, steadfast support, and wise counsel. So, James C. Aboud, today we bid you farewell from this place that you love so much. But your work will continue, I am sure. Looking at you, no one would believe that you have attained the statutory age of retirement. You are lucky to be blessed with good health and a youthful manner. May you thoroughly enjoy your retirement, and may you continue to be the good soul that you are in the times that lie ahead. I will now invite my brother, Justice of Appeal Musai, to give remarks. Thank you.
Thank you, Chief Justice. Today, we mark the retirement of a judge whose career has reflected intellect, independence, humanity, and an unwavering commitment to justice. Justice James Christopher Aboud leaves the bench after approximately 18 years of judicial service, some 13 years in the High Court, followed by 5 years in the Court of Appeal after his elevation in 2021. Those numbers alone speak to longevity and industry, but they do not fully capture the quality of the contribution which he has made to the jurisprudence of Trinidad and Tobago. Justice Aboud comes from a family whose name is deeply woven into the commercial history of this nation. The Aboud's family contribution to enterprise and entrepreneurship, particularly in the textile trade, forms part of the commercial fabric of Trinidad and Tobago itself. It is perhaps unsurprising, therefore, that throughout his judicial career, he demonstrated an instinctive understanding of commerce, bargaining, practical reality, and the dynamics of human negotiation. I myself have witnessed this remarkable transformation from what you may say is from cloth to court. Indeed, many litigants who appeared before him in settlement discussions would have encountered what Justice Aboud himself proudly describes as Queen Street textile bargaining logic. In disputes involving monies due and owing, he had a remarkable ability to reduce a highly emotional conflict to their essential arithmetic. He understood that litigation frequently disguises simple economic truths beneath layers of pride, frustration, and positioning. And he consistently believed that the object of settlement was not the humiliation of one side by another, but the attainment of a result in which both parties could leave with dignity intact. Justice Aboud often expressed the view that the doors of the negotiation room should remain closed, in the sense that negotiations should remain confidential, private, and protected from public exposure or later recrimination, and that it is far better to have two winners than one victor and one casualty. That philosophy reflects not only commercial wisdom, but also judicial wisdom. It recognizes that the administration of justice is not merely about deciding disputes. It is also about resolving them in a manner that preserves social and commercial relationships where possible. His judicial output has been substantial. He is credited with approximately 203 judgments, roughly evenly divided between the years in the High Court and in the Court of Appeal. And those figures, I'm sure, do not include the many oral decisions he delivered over the years with characteristic clarity and efficiency. I wanted to include brevity, but I took it off. But Justice Aboud's contribution cannot be measured merely by numbers. His judgments consistently displayed careful reasoning, logical structure, and analytical discipline. He possessed an ability, particularly in commercial and contractual disputes, to penetrate complexity and identify the true engine driving the controversy. That quality was perhaps evident in the recent matter of Central Bank and Montai, where his appreciation of commercial realities and complicated business transactions proved pivotal to the court's determination. He brought to that matter not merely legal analysis, but commercial insight born of lived understanding. He appreciated that the law governing business transactions cannot sensibly be divorced from the practical world in which commerce actually operates. He even invoked Fannie Mae and Freddie Mac and the global financial crisis of 2008 in his judgment. His intellectual path to the law was itself unusual and enriching. Before obtaining his LLB and being called to the bar in both England and Trinidad and Tobago, Justice Aboud first pursued English literature and later obtained a postgraduate diploma in international relations. Those disciplines left their mark upon him. The student of literature became the judge, attentive to language. The student of international relations became the jurist, conscious of broader institutional and societal context. And perhaps that literary background also explains another aspect of Justice Aboud, which many outside the legal fraternity may not fully appreciate. He is an accomplished poet. His publication, Lagahu Poems, received the distinguished James Rodway Prize, awarded by none other than Nobel laureate Derek Walcott and Boston University. That is no small achievement. It reminds us that behind the judicial robe stood not merely a legal mind, but a creative one, a man attentive to rhythm, language, metaphor, and the complexities of the human condition. I had occasion early in my tenure in the Court of Appeal to sit on an appeal emanating from Justice Aboud's judgment in the Statutory Authority Service Commission versus Solomon Sanker. In that matter, the Court of Appeal upheld his conclusion that a transfer policy from one statutory authority to another, which disregarded years of prior service when preparing a seniority list, was unauthorized and unlawful. What struck me then was the clarity of his reasoning and the firmness with which he approached questions of legality and fairness. That same forthrightness became one of the hallmarks of his service in the Court of Appeal. In our panel discussions in the Court of Appeal, before entering the courtroom, Justice Aboud, as the Chief Justice indicated, never concealed his views. Whether his position happened to coincide with the majority or place him in the minority, he expressed it candidly, independently, and without hesitation. And where he felt strongly that justice required a different course, he was entirely prepared to dissent. I think he's written quite a few dissenting judgments in the Court of Appeal. That independence of mind is an indispensable judicial virtue. Collegiality on an appellate court is important, but true collegiality does not require conformity. Justice Aboud understood that a judge's ultimate loyalty is owed not to consensus, but to conscience and the law and the interests of justice. Now, no tribute to Justice Aboud would be complete without mention of one particular feature of his judicial personality, a feature which some of us experience rather directly and was referred to by the Chief Justice. Given his English literature background, he possesses a most enthusiastic commitment to sentence construction and syntax. One might send him a draft judgment, believing it to be perfectly satisfactory, only to have it returned heavily redlined with suggested revisions. Now, one accepts the first revision graciously enough, but then comes the second, the third, and sometimes even the fourth. There were occasions when I confess as president of the court, I simply ignored the later draft. But make no mistake, James would go through a judgment line by line, sentence by sentence, word by word. To him, precision of language mattered, syntax mattered, clarity mattered. And while some of us may occasionally have groaned upon seeing yet another set of amendments arrive, those interventions invariably reflected the seriousness with which he approached judicial writing. The attention to language was not pedantry for its own sake. It reflected a deeper judicial philosophy that words matter because justice itself is communicated through words. Unless you think otherwise, there was no red line drawn in the sand. Successive Chief Justices have also been subjected to redlining. Moreover, in court, he has been known to suggest to younger attorneys ways and means to improve their oratorial and courtroom skills. As Justice Aboud now lays down the burdens of judicial office, he does so with much to be proud of: a distinguished judicial career, a respected body of jurisprudence, the esteem of colleagues, and the affection of friends. No account of Justice Aboud's distinguished career would be complete without acknowledging the unconditional support of his family. Side by side with the poet and the jurist stands his wife, Shan, whose unwavering encouragement and strength, and as we all know, charisma, undoubtedly made possible the many demands of public life and judicial office. Together, they have raised 3 exceptionally accomplished daughters, Emily, Rebecca, and Vivian, each of whom has excelled academically and reflected the same discipline and intellectual distinction so evident in their mother and father. Regrettably, their eldest daughter, Emily, could not be here today, as she's pursuing her theatrical career on what I believe is the London stage. And as you know, Justice Aboud, the show must go on. But Emily does want me to say on behalf of the kids, and I quote, "Dad, I'm so honored to be your daughter. You have set a precedent for my sisters and I to work hard at our passions through roads less traveled, trusting that we have the support of our family. The passion you have for the written word is so clear in your decades of writing judgments. The world of poetry and prose await you. We are all so proud of you," close quote. But beyond the judgments and the statistics, I suspect many of us will remember most vividly the person himself: intelligent, very independent, analytical, cultured, sartorially elegant, commercially astute, occasionally stubborn, I don't know whether the family will agree with occasionally, and always deeply committed to getting the answer right. Justice James Christopher Aboud, on behalf of your colleagues, we thank you for your service to the judiciary and to the people of Trinidad and Tobago. We wish you and your family health, peace, continued intellectual fulfillment, and every blessing in the years ahead. And knowing you, I suspect retirement will not mean silence. Thank you.
Thank you very much, Justice of Appeal Musai. May I invite the President of the Law Association, Mrs. Sibran Sweet, Senior Counsel, to address us.
My Lord Chief Justice, Lords and Ladies, Mr. Justice of Appeal James Aboud, distinguished members of the legal profession, invited guests, ladies and gentlemen, good morning. It is a singular honor to appear on behalf of the Law Association of Trinidad and Tobago to pay tribute to the Honourable Mr. Justice of Appeal James Aboud on the occasion of his retirement from the Court of Appeal. Today, we celebrate not merely the conclusion of an illustrious judicial career, but the enduring legacy of a jurist whose contribution to the administration of justice in Trinidad and Tobago has been profound, distinguished, and deeply respected. Justice Aboud's career reflects a life dedicated not only to the law, but also to scholarship, to culture, to public service, and national development. His journey to the bench was marked by academic distinction and intellectual breadth. Prior to his judicial appointment, he demonstrated a strong commitment to public service, having served as a commissioner of the Public Utilities Commission from 1987 to 1993, where he heard contested applications for rate increases and discharged significant regulatory responsibilities. His service to the law has been defined by intellectual rigor, meticulous preparation, and an unswavering commitment to the proper administration of justice. Throughout his tenure on the bench, he embodied the hallmarks of excellence, independence of thought, clarity of reasoning, patience in hearing, courtesy in conduct, and fidelity to the rule of law. In 2006, Justice Aboud accepted appointment, I beg your pardon, as an acting High Court judge assigned to the Supreme Court in San Fernando. It was there that many first observed the extraordinary diligence and work ethic that would come to define his judicial career. Faced with a substantial backlog of matters under the former rules of the Supreme Court, he worked tirelessly to restore efficiency to the administration of justice. It soon became well known within the profession that he would frequently sit late into the evenings, sometimes until 7 o'clock on a Friday night, to complete matters that had long remained unresolved. What some described as notable and at times remarkable was in truth a clear expression of his dedication to justice and his respect for litigants awaiting the determination of their cases. In 2010, Justice Aboud was appointed a judge of the High Court and was later elevated to the Court of Appeal. Throughout his years on the bench, he distinguished himself as a jurist of intellect, diligence, and humanity. He consistently approached the law not merely as a system of rules, but as an instrument through which justice must ultimately be achieved. Members of the profession of law regarded him as a judge who brought care and mastery to every matter before him. His judgments reflect analytical precision, practical wisdom, and a deep appreciation for fairness and procedural justice. In the Court of Appeal, Justice Aboud made a significant contribution to the development of constitutional law, civil procedure, and the broader substantive jurisprudence of Trinidad and Tobago. His judgments often demonstrated a careful balance between strict procedural compliance and the overarching interests of justice. In appeals concerning evidential rulings, trial procedure, and matters involving both major state entities and corporate litigants, his reasoning consistently reflected a commitment to ensuring that litigation proceeded on sound legal principles and within the framework of the rules. Beyond technical legal analysis, his judgments conveyed a broader judicial philosophy, that the courts exist to resolve real disputes fairly, efficiently, and with integrity. What makes Justice Aboud especially distinctive, however, is the rare combination of jurist and artist. Long before and throughout his judicial career, he established himself as a respected poet and literary figure. His collection of poems, Lagahu Poems, earned the James Rodway Poetry Prize in 2004, awarded by the late Nobel laureate Derek Walcott and Boston University. His writing reflected the same qualities that define his judicial work: intelligence, discipline, humanity, and a profound command of the language. It is fitting that a man so deeply rooted in literature brought such richness and cultural sensitivity to the law. Justice Aboud reminded us that legal reasoning need not be devoid of humanity, that precision and compassion can coexist, and that justice must always be understood within the broader context of human experience. The Law Association also acknowledges the respect and civility with which he engaged members of the profession. In an era where the pressures on the justice system continue to grow, such qualities are especially significant. They strengthen public confidence in the courts and reaffirm that justice must always be administered with humanity, dignity, and respect. Retirement from judicial office marks the end of one chapter, but it also provides an opportunity to reflect on a career of service that has profoundly enriched the legal landscape. While the judiciary will undoubtedly feel the loss of experience and wisdom, we trust that Justice Aboud will now enjoy the opportunity to pursue the many personal interests and opportunities that must by necessity yield to the demands of public service. On behalf of the Council and members of the Law Association of Trinidad and Tobago, and on my own behalf, I extend sincere gratitude to you for your outstanding contribution to the judiciary, to the legal profession, and to the people of Trinidad and Tobago. Thank you.
Thank you very much, Mrs. Seabrand-Sweet. May I invite Mr. Douglas Mendez, Senior Counsel, to address us.
Honourable Chief Justice, Justices of Appeal, former President of the Caribbean Court of Justice, Justice Adrian Saunders, current Justice of the Caribbean Court of Justice, Justice Peter Jamadar, Justice Teresa Haddad of the BVI Court, former President of the Republic, His Excellency Mr. Tony Carmona, and of course, Justice of Appeal James Aboud. James, if I may, from time to time, Chief Justice, James's wonderful family, the President of the Law Association, of course, all of my colleagues at the bar, friends, and invited guests. It is my special pleasure to offer some remarks at this special sitting of the Court of Appeal, marking the retirement of Justice Aboud from the Court of Appeal of Trinidad and Tobago. It is my pleasure because I consider James a friend and a trusted collaborator in the pursuit of the rule of law and constitutional rights. I consider him my friend because we met quite a long time ago at Cave Hill in Barbados in the second year of the LLB program at the University of the West Indies. I couldn't remember if I met James before then. If I did, he probably won't remember because it's most likely to have been on the tennis court where I probably meted out some beating to him. James was joined at Cave Hill by B.C. Pearies, the iconoclastic journalist. Baz was James' best friend since they were young teenagers. It was B.C. who recorded for posterity the fact that in the Aboud family, the customary way of beginning speeches on important occasions such as this one was to say, and I quote, "Lady and gentlemen, it gave me great pleasure, or I should say it gave me great pressure to give address to such extinguished company on such a suspicious occasion." No. Chief Justice, you will forgive me for choosing a more traditional introduction. James was also joined at Cave Hill by His Excellency Mr. Tony Carmona, former President of the Republic, who at the time went by the stage name the Prophet of Sisyphus. He was a Calypsonian, you see, and in fact competed in the semifinals of the Calypso competition. It used to be called that at the time, Calypso King competition. He was also joined at that time by David Alexander, who was a budding pianist and was very fond of a certain number by Rodney Franklin, which I'm sure he'd remember because we played it so many times. I mentioned Baz, Tony, and David because they were James's kindred spirits. He himself being an emerging poet, as those before me have mentioned, because he had already read a degree by that time in English literature at Western University, where he graduated with honors, switching to law while he was in the midst of a master's program. He was a later author of two collection of poems, as mentioned, one, the Lagahu poems, which won the award already mentioned, but there was a second collection entitled The Stone Rose. His poems have been included in various regional and international literary journals and anthologies. James also studied law with our cherished friend and colleague, Emile Ferdinand, King's Counsel from St. Kitts and Nevis, who James has asked me to repeat what he told you already, that you retire with your integrity and work ethic intact. All of us eventually commenced our legal practices. DC left law not long afterwards to become a full-time journalist and commentator. James became a judge in around 2010, being elevated in 2021 it is. I was to discover that he joined a long tradition of poets who turned to law or took up judicial office, one of the most famous of which is Sir William Blackstone, who famously wrote the commentaries on the laws of England after he had penned the poem, The Lawyer's Farewell to His Muse. I imagine James declaring, as he took judicial office, as Blackstone did in his poem, quote, "The drowsy bench, the babbling hall, for thee, fair justice, welcome all." In reading and rereading James's judgment, I have found James the poet to be reflected in the writing of James the jurist. Not that his language is flowery or even abstract, but rather in his conversational style of delivering judgment, as if he were laid back in his veranda explaining things. It is sometimes reflected in his impish historical references, as when he chided senior counsel's client for turning a Nelsonian blind eye to a regulatory omission. It just so happens that said senior counsel was none other than the former CCJ judge, Ralston Nelson. It is also reflected in the same case in his quotation of the phrase attributed to the Roman poet Catullus, referring to things, quote, written not on air or running water, close quotations. Or in more mundane fashion, when he schooled all of us in the etymology of the word should, which I was made to understand is not a, quote, polysemic word, and it is strictly speaking the past tense of shall, and is therefore not to be construed as the permissive may. I confess that I had to look up the meaning of the word polysemic. His relaxed and conversational style is also reflected in the unique headings that populated his judgments, substituting, quote, what we heard in the Court of Appeal for the usual heading, grounds of appeal, or the phrase, what the respondent said in reply, for the usual, the respondent's case. More significantly, though, he also had his own way of expressing well-worn and stodgy constitutional formulations, as in the way he rejected any notion that constitutional remedies were to be used sparingly. The Constitution, he said, was not, quote, a document meant to exist in any obscure or inaccessible tower. Neither was it to be, quote, sheltered behind veils of legalistic abstraction, those quotations. Or in the way he expressed the judicial exercise of constitutional interpretation as involving a constitutional court, quote, with the pages of the Constitution open before it, giving generous support to its provisions, especially those that enshrine the fundamental rights and freedoms, close quotation. This was his more poetic way of saying that the Constitution is to be construed as a living tree, not to be subjected to the austerity of tabulated legalism. Of course, his contribution to the development of Caribbean jurisprudence has not been limited to the stylistic. James has led this court in a number of pivotal cases. I mention only a few. His decision in Boxall exploring the circumstances in which statutory bodies such as the Port Authority would be subject to constitutional remedies has been revelatory, earning the recognition of our highest court as an impressive judgment. His ruling unappealed that judges were eligible for sabbatical leave not only had an immediate impact on the terms and conditions of service of judges, but illuminated the jurisprudential landscape as it relates to the independence of the judiciary and the part which the Salary Review Commission plays in insulating the judiciary from untoward influence by the executive. His decision in the nephrology case exploring the fine divide between public and private law, and his declaration that the right to life could not impose state obligations which would foist upon the judiciary the task of determining how best the state should allocate scarce resources across the services in the healthcare system, established important markers in our understanding of the Constitution. His very recent decision in Christian Can, limiting the reach of the savings law clause, will be memorable, as will his determination in the same case that a law which regulated the facial hair of Muslim police officers violated the right to equality. I admire this statement in his judgment. Quote, in a racially diverse, multicultural religious society like ours, it is difficult to identify any justifiable public interest for a policy that imposes the substantial restriction on the religious practices of individuals, namely devout Muslim officers. Close quotation. Quite apart from leading the court on important issues, Justice Aboud has kept his colleagues on their toes with important dissents, as Justice Musa has mentioned, not least of which are one of his most recent about the applicability of the tort of nuisance, and his less recent dissent on the constitutionality of the search warrant of the offices of a daily newspaper. The importance of dissenting judgments lie not only in the fact that they frequently turn out in later years to be right, but they force among and between members of the judiciary a healthy, if sometimes stressful, intellectual jurisprudential exchange, which can only result in the refining of legal propositions and the improved quality of output. I gather that Justice Aboud has done his part in this regard in spades, Justice Musai. 16 years is a long time in any endeavor. James, you have served us well. You will be remembered for the joyous way in which you approach your judicial task and engage with counsel, the courtesy which you displayed in the course of arguments, your politeness and friendliness, and most enduring, your contribution to the development of Caribbean jurisprudence. You will certainly be missed.
Thank you very much, Mr. Mendes. May I now invite Justice of Appeal Aboud to reply.
I begin by thanking those in attendance. I could go through the list that Douglas just went through, but everyone knows the rank and seniority of everyone in this room. My dear wife, Shan, and daughters, you already know how sad I am to pull up the anchor of my judicial career. It grounded me to the shore for 18 years, spent away from you in my untidy study, writing judgments and preparing to hear cases. It was a challenge for you, but a joy for me and an arduous vocation. In the 1920s, my grandparents arrived here as penniless peasants from the Turkish province of Greater Assyria. They were Greek Orthodox Christians and were second-class citizens for some 400 years. My paternal grandfather, Khalil Aboud, a farmer from whom I get my name, was forcibly conscripted into the Turkish army in World War I, was blinded in one eye by mustard gas, escaped, was captured by the Turks, and imprisoned as a deserter. My maternal grandfather, Najib Elias, was a shoemaker, and his wife, Linda, was a seamstress. They made shoes and dresses for your grandparents and great-grandparents. When the Europeans became the new colonizers of their homelands, my grandparents were given French or British passports, and they fled to Trinidad. When my maternal grandfather, Najib Elias, arrived here from Marseille in the mid-1920s, he had 18 cents in his pocket. These are my roots. My father, Jimmy Aboud, lived in a 2-bedroom apartment with 8 siblings above a noisy rum shop on Prince Street. For dinner, he ate biscuits with condensed milk. Hungry one night, he drank straight from the tin and swallowed a cockroach. He was forced to leave school at age 14 to become a traveling salesman with a suitcase on his head. He went everywhere in Trinidad selling his pins and needles. I remind you of this because my Middle Eastern Trinidadian roots are humble and impoverished. A people persecuted for hundreds of years are now unfairly facing yet another persecution in the land of their birth. I began practice as a trespassing door tenant at the chambers of Trevor Lee, Senior Counsel, together with Sinat Jairam, Fayed Hussain, Ernestine Seeley, and Henley Wooding. Having become a barrister with no recognizable name in this profession, Frank Solomon, Senior Counsel, saw something in me and gave me my first big briefs. So too did Sunny Miraj, Senior Counsel, and Ewart Thorne, Queen's Counsel. In 1997, Chief Justice Michael Elabaside invited me to join the judiciary, but my obligations to my father's business prevented me. Eventually, Chief Justice Sat Sharma appointed me as an acting judge in 2006. I was assigned permanently to the San Fernando High Court to clear up the huge backlog of undetermined trials. I sat there for almost 2 years. According to the records, my disposal rate was 72.5%. I knew nothing about adjudication in 2006. Everything I learned about being a judge was learned in San Fernando. Oh, how I trembled when Ramesh Maraj, his gifted and dearly departed wife Lynette Maraj, Kemraj Hari Kisoon, Hendrickson Sunat, and others appeared before me in those first few months. I owe everything to them. Iron sharpens iron. At that time, Anand Ramlogan was a junior counsel, an advanced non-discrimination jurisprudence in novel directions. One junior counsel at that time was my old NAR colleague who won an important case involving some Bajan fishermen against the astute, respected, and gifted Russell Martineau, Senior Counsel, to whom I now pay honor. My judgment in that case was upheld by Peter Jamada, Justice of Appeal, as he then was, in the Court of Appeal. That lady lawyer is now our Prime Minister. I invited many of those lawyers to attend today's sitting, including Winston Sunat, Senior Counsel, Dipnarayan Rampasad, Senior Counsel, and my favorite of all, Edwin Rupnarayan, a stalwart at the bar for over 50 years, often wearing a beautiful flower in his lapel. As I think from this distance, I can see a flower, Mr. Rupnarayan. He lost a few cases before me, despite his lapel flowers. It was never his fault, but that of his clients. Lawyers do not lose cases. Their clients lose cases. Litigants are idiosyncratic and often call upon lawyers only after they have, by their own choices, found themselves in trouble. It would be remiss of me not to mention the name of my JSO for those 2 years in San Fernando, namely Marilyn Supdio, who soldiered on with me. No, I don't think she's here today, but she's looking on probably on a live feed. She soldiered on with me many times late at night. In fact, one case was the case of Dan Steele versus Bhagwan Singhs, where the brother and sister who had fallen into dispute. And we were sitting, and it was all 5 minutes past 7 o'clock in the night. And I think they were pretty much worn out, but I did encourage the brother and sister, knowing what has happened in my own family, insofar as family breakdowns and dysfunctionality is concerned, that the brother and sister should find a way to resolve the dispute. The brother and sister shook hands, hugged, and settled the matter in my courtroom. And a short while after that, the brother died. But I felt very happy. I felt very happy that I had brought peace to that family. So I thank you, my dear San Fernando lawyers, for teaching me how to be a judge and launching my judicial career. Mention has been made already about my, I don't know why that word has now fallen into current usage, but one would say he is anal about language. Don't ask me to explain. It's probably, Ms. Raymond will probably know that it derives from a Freudian concept, probably. But I have been very fastidious about language, and I'm not going to say it again. Others have mentioned that. But I will say that 2 Chief Justices have never been spared my abundant language and legal corrections. And I apologize to you, Ronnie. Like the textile king, I am the red line correction king. Wherever I felt that the majority opinion in the Court of Appeal was wrong, I wrote a dissenting judgment. And Douglas, you have mentioned 2 recent ones in Attorney General versus One Caribbean Media Limited and Western Industrial versus J.T. Allen. I feel 100% confident that those dissents are correct and the majority has fallen into error. Nothing could make me change my mind. Is that Mr. Masai sitting in the back? Mr. Masai, for whatever reason, no matter how many times, I have been very strict with you in court because of your exuberance of expression and because of your overexcitement and getting your point over and sometimes even interrupting your learned friends. Through all of that, you have always said the very kindest things about me, Mr. Masai. And it surprises me. It surprises me. But it must mean, sir, it must mean that you and I share some kindred spirit. It maybe we express it differently, but search for the law and correctness in the law. So I honor you, Junior Counsel Masai. A dissent takes time to write, but dissent is essential in a democratic society. I never had a fear of being in the minority or of swimming against the tide. In the case that Mr. Mendez refers to, that was approved by Lord Walker in the Privy Council, namely Boxhill versus the Port Authority, Elton Prescott, Senior Counsel, who appeared on behalf of the Port Authority, warned me not to become an activist judge. In that judgment, I boldly held that a public authority was susceptible to a claim under the Constitution in the same way as the state. Mr. Maraj, you asked me to disregard what Mr. Prescott said. And I, in fact, asked you, Mr. Maraj, you could have brought this claim by way of an ordinary civil action, but did you deliberately choose the constitutional route? And you said, to my great surprise, yes, I did. I then realized, Mr. Maraj, that you were pushing the boundaries of the law. And no judge can be great without a vibrant and inspired bar. No judge. A judge doesn't just come up with his ideas. A judge is prodded along in a direction that is novel. And in that case, Mr. Maraj, well, you were vindicated. My judgment was vindicated in the Privy Council. But interpreting the law to arrive at justice is not and can never be described as judicial activism. Our goal as judges must always be to actively arrive at justice for all, whether it is a state or a citizen. Bernard Shaw said this: the reasonable man adapts himself to society. The unreasonable man expects society to adapt itself to him. Therefore, all progress depends upon the unreasonable man. Hope His Majesty's Privy Council will eventually sort out all my dissenting judgments. Hopefully one day in our lifetimes, the task of determining final appeals will be vested in the Caribbean Court of Justice and not in His Majesty's Privy Council. Insofar as my well-known record in obtaining amicable settlements in cases before the High Court and Court of Appeal is concerned, I briefly say this to younger judges. A dispute is always between litigants and never between lawyers. A citizen is often not as warlike and unforgiving as his or her lawyer. With the lawyer's permission, a judge can speak directly to the litigant without any bias to inquire into their differing senses of justice. A judge must establish his or her sincerity in being fair-minded to both litigants. Sincerity is absolutely essential. Sincerity begins in the heart and is not a learnt virtue. If a judge is not sincere, it is because of an unconscious bias or by not studying the file to get to the heart of the real dispute. Sometimes people fight in court because of egotism. A judge must be alive to these human feelings in litigants. Litigants prefer to be somewhere else rather than paying lawyers and sitting in court with all of the trauma and inconvenience that it engenders. Almost all litigants prefer a compromise all-win solution to a win-lose situation. Finally, everything depends on the heartfelt and unbiased sincerity of the judge. You have heard mention of the application of my Queen Street attitude to business, and what I can say is that I have always applied a mom and pop shop approach in resolving and trying to understand the most complicated of commercial disputes. I am not ashamed to say that. A contract is a contract, whether buying 3 yards of cloth for $25 or investing $100 million in mutual funds and government bonds. Douglas, you have, I may call you Douglas, but we are sitting in open court, let me remind you, so don't take any liberties yourself. Two, I want to recognize, as Douglas did, my LLB gang from UE, Keyville, particularly from those from Casa Alicia. And that includes you, Douglas, Emil Ferdinand, Dave Alexander, and Tony Carmona. I also recognize Peter Jamada, Wendell Kangaloo, dearly departed, Sanjay Bihari, and my beloved BCP Rees. Behind me sit the members of the Court of Appeal. It has been my honor and the greatest privilege of my life to be of use to you, my brothers and sisters, and to our Republic of Trinidad and Tobago. Thank you, appellate judges, for putting up with my sometimes inconvenient but sincere notions of justice, my too often inappropriate sense of humor, and my unrelenting insistence on getting our judgments right. I live at a time in our history when we are plagued by crime. And I think it is time to tackle it, if I may say so. The society owes incarcerated persons who made mistakes like all of us a chance to re-enter society as law-abiding members. Is the alarming increase in crime rates connected to recidivists or repeat offenders? Has our prison system become a university of crime? Together with Justice of Appeal Carla Brown and Twine and the underappreciated Debbie Jacob, I will continue my work with prisoners beginning next month. Shea Lovelace, the eminent painter, and I will also begin visiting crime hotspots later this year or the next year to start bending minds. With apologies to my beloved twin brother, Gregory Aboud, who is here today, he will also be conscripted. Perhaps we will together be able to free the creativity and entrepreneurship of these deliberately forgotten brothers and sisters. My daughters, Rebecca and Vivian, have flown in for this special sitting. Hello, my darlings. I miss you, my daughter Emily, a theatre director in London. The show must go on, as Justice Musai said. Despite all of my advice to the contrary, Vivian ignored me and chose to become a barrister at law, and was last year called to the bar at Middle Temple, my Inn of Court. I love that you ignored my advice, Vivian. Dissent runs in our family. In coming to this decision, I applied in 1963 judgment of the House of Lords in Jones and Padavatan, which, as you reminded me, is still good law. As I told Vivian, becoming a lawyer or a judge must never be a career choice. That is surely a stupid reason. We should not face the horrors of becoming either a lawyer or a judge for the reward of money or fame. Money or fame have absolutely nothing to do with the practice of law or of judging. This is a vocation, and not a career choice. Those judges sitting behind me and those lawyers sitting in front know this only too well. Burning the midnight oil after a day in court is an obligation done by all of us with the love of justice and nothing else. Egotism, fame, and money is a poison. Long live our Caribbean civilization. Long may our lawyers endure at the bar and on the bench in the pursuit of their vocation. If you will allow me, and I don't know if I have 2 more minutes, Chief Justice, I would like to read a short passage from one of my favorite poems by T.S. Eliot. Do I have that time?
Of course.
This is from Eliot's poem, The Love Song of J. Alfred Prufrock, and I think it encapsulates my career as a judge and indeed my entire life. Eliot wrote this when he was just 23 years old in 1921. I am not Prince Hamlet, nor was meant to be. I am an attendant lord, one that will do to swell a progress, start a scene or two, advise the prince, no doubt, an easy tool, deferential, glad to be of use, politic, cautious, and meticulous, full of high sentence, but a bit obtuse. At times, indeed, almost ridiculous, almost at times, the fool. I grow old, I grow old. I shall wear the bottoms of my trousers rolled. Shall I part my hair behind? Do I dare to eat a peach? I shall wear white flannel trousers and walk upon the beach. I have heard the mermaids singing each to each. I do not think that they will sing to me. I have seen them riding seaward on the waves, combing the white hair of the waves blown back. When the wind blows the water white and black, we have lingered in the chambers of the sea by seagulls wreathed with seaweed red and brown, till human voices wake us and we drown. I now say goodbye to this beloved courtroom. My heart is heavy. Kabi kushi, kabi gam, which means sometimes happiness, sometimes sadness, for those who are familiar with Bollywood movies. Thank you for listening to me. Goodbye.
Might I invite all of us gathered to join in paying tribute to Justice Aboud by a hearty round of applause. I will direct the registrar to prepare a transcript of these proceedings to be sent to the Honourable Mr. Justice of Appeal James C. Aboud. I would like to thank, on behalf of the judiciary, all of you for attending today, each of you for attending, family members, friends, and in particular, our judicial colleagues, both current and former, for taking the time to come out today. We've also had viewing online. This is important to recognize the work of a distinguished jurist, but it is also a way of our profession coming together and maintaining our important traditions. So I thank you for your attendance today. And again, we wish Justice Aboud a very happy, long, and fulfilling retirement. And we do have more work for him to do, which we will be talking to him about soon. So thank you again. And I would now say that court is now to be adjourned.